I am pleased to introduce to you John Q. Barrett, the Elizabeth S. Linnae Fellow at the Jackson Center. John is a trusted advisor and excellent friend to this institution and its leadership. He's a graduate of Georgetown University and the Harvard Law School, and he teaches law at the School of Law at St. John's University. He is the editor of That Man, an insider's portrait of Franklin D. Roosevelt, Justice Jackson's previously unknown memoir of FDR and the New Deal. He is currently working on a biography of Justice Jackson, which will provide the first insider's account of his year away from the Supreme Court, serving as Chief American Prosecutor at the International Military Tribunal in Nuremberg. Ladies and gentlemen, please join me in welcoming John Barrett to the podium.
Thank you very much. Good afternoon. I do have the unfortunate responsibility to begin with a terrible topic: the impending bankruptcy, the financial failure, the devastation, and imminent closure of Chautauqua Institution. Luckily, I speak of 1936. And Chautauqua Institution, from its leadership and people outward, at that point had the vision and the reach to survive, to resume its upward trajectory, and indeed, as we see here today, to flourish. The president of Chautauqua at that moment was Arthur Bester, a great scholar and leader long before he was a plaza, and indeed a national figure in the world of ideas, education, and public communication, the leader of the Town Hall of the Air, among other responsibilities that filled his very full year. And in that summer of 1936, Arthur Bester reached out to a close friend and a son of Chautauqua, Robert H. Jackson. Jackson was a native of Pennsylvania, raised in New York State, a Jamestown product, a lifelong Chautauquan, and by 1936, an Assistant Attorney General of the United States, already making his mark as a distinguished Supreme Court advocate. Indeed, at that point, Jackson was being boomed, as the word was used then, for Governor of New York, and or Solicitor General of the United States, and or Attorney General of the United States, and or appointment to the United States Supreme Court, some of which came to pass. Indeed, even at that early moment, there was talk of Robert Jackson as a future President of the United States, talk that became much more pronounced in the next 3 years. But in the short term, that office was occupied. And in that summer of 1936, Robert Jackson got his boss, his friend, his close confidant, the President, Franklin D. Roosevelt, also a friend of Bester, to keep a promise that FDR had made at the start of his presidency to Bester. The promise was before the first term was out, he, FDR, would come to Chautauqua. And Jackson made it happen. And FDR came here on August 14, 1936, delivered in the amphitheater the speech that we, of course, remember as I Hate War. And as his party's nominee, of course, that was a political event, and he was matched by his contenders, Republican nominee Alf Landon, Socialist Party nominee Norman Thomas. Indeed, even the Prohibition Party candidate also followed Roosevelt to Chautauqua before that summer was out. And the gate combined, the ticket sales of those four speakers saved Chautauqua in the depths of the Depression. A year later, 1937, Jackson's star had risen even higher. He was still an Assistant Attorney General, but he'd had a busy year arguing before the U.S. Supreme Court, including arguing and winning the decision upholding the constitutionality of the Social Security Act. The Supreme Court in that summer of 1937 was, of course, the topic of the nation. That was the summer, following on the spring and the winter, of the court packing proposal. That was the re-elected Roosevelt proposing legislation that would have probably allowed him to enlarge the court and dilute the votes of the justices who had been the first-term obstacles to New Deal legislation. And in that summer of 1937, Robert Jackson, in a sense, continued what he'd done the previous summer with FDR. In 1937, he brought his close friend, the Solicitor General of the United States, Stanley Reed, here to speak at the Chautauqua Institution. Serendipitously, that date was July 9, 1937, 76 years ago today. Stanley Reed was the speaker who attracted a huge gate, believe it or not, on what Chautauqua denominated Lawyers' Day. And throngs of lawyers came in to hear the Solicitor General in that time of a Supreme Court having turned and upholding the New Deal, talk about federalism, the continuing place of the states in our national system of constitutional organization. From 1937 and ever since, I think, Lawyers' Day and Lawyers' Talk has become the stuff of all of us. We are all law people. Court packing, of course, failed, but in terms of public salience, court watching, court awareness, court engagement, I think is part of our history since then. It's certainly part of the elite, educated, attentive public's history, and here you are. And the braided connection between Chautauqua Institution and the Supreme Court has continued in those 76 years ever since. It's become thicker and it's become tighter. For example, on July 4, 1947, Robert Jackson, who in the meantime had become the Solicitor General and the Attorney General and the U.S. Supreme Court Justice and the Nuremberg prosecutor, came here to speak on the 4th of July about his experience working with Soviets and his conviction that although signs were dire and many were speaking pessimistically, a World War III was not inevitable because of the rule of law, including our constitutional system. In October 1954, 8 Supreme Court justices came here to Chautauqua Institution. Now you might wonder, what kind of a panel was that, right? It was October. It was the off-season. The lake was dappled with sunlight and the leaves were fall colors. And the 8 had just finished burying their colleague Robert Jackson in Frewsburg. But before they left Chautauqua County, they insisted to come here and see Chautauqua Institution, the thing Jackson had talked to them about in such detail over the many years of their collaborations. In 1957, Thurgood Marshall, Secretary General Counsel of the NAACP Legal Defense Fund, still in his future a Solicitor General, not yet a Solicitor General, came here to speak a couple of years after Brown, very optimistically about America's destination soon in successful desegregation. And of course, in modern times, justices have come to grace the Chautauqua grounds, including O'Connor and Kennedy, and in week 6 ahead, Justice Ginsburg. In 2005, Chautauqua Institution with the Jackson Center formalized this venue, this occasion, a Robert H. Jackson lecture, to commemorate and honor Jackson and to bring here some great figures, some true experts, some real insiders to consider the work of the U.S. Supreme Court at a moment shortly following the conclusion of the court's annual term. And thus, over the past 8 years, it's been a list of luminaries, and I hope that many of you have been here on prior occasions. Jeffrey Stone, Linda Greenhouse, Jeff Schessel, Seth Waxman, Paul Clement, Dahlia Lithwick, Pamela Carlin. 2 of those are former Solicitors General. Maybe 1 or more is a future Solicitor General. It adds up to, since 1937, a very elite club of current, future, former Solicitors General and others talking about the work of the Supreme Court. Stanley Reed, Robert Jackson, Thurgood Marshall, Paul Clement, Seth Waxman. Now what's the Solicitor General? Well, in Robert Jackson's words, it's the best job on earth for any lawyer ever. It's the legal representative of the United States government in the courts of this country, including particularly in the U.S. Supreme Court. And it, of course, is a political appointment and moves from hand to hand, but has generally been represented by the greatest among our legal profession. Today, joining that roster is an alumnus of that best job. Now, I'm not sure he'd use it as his best job. But Charles Freed, born in Prague, raised briefly in England, then in the United States, educated in England and the United States, a graduate of Columbia Law School, a former law clerk to Justice John Marshall Harlan, since 1961 a professor at Harvard Law School, interrupted in the 1990s by service on the Supreme Judicial Court of Massachusetts, and earlier in the 1980s by a 4-year stint as the Solicitor General of the United States, is today's Jackson lecturer. Charles Freed is a great thinker, writer, lawyer, and teacher. As a passing question, I'm curious which of those he ranks as his best job. But it is a great honor to welcome him here today for the 9th annual Robert H. Jackson Lecture on the Supreme Court of the United States. Charles.
Thank you very much for that. I'm going to talk today about mysteries, puzzles in the previous terms and the last term, the one just completed, in major cases, real puzzles. The puzzles from the 2011 term is the healthcare case, and the puzzles from the 2012 term are the two same-sex marriage cases, the DOMA and the Proposition 8 cases. Both the marriage cases and the healthcare cases have an enormous effect on, or at least address, issues that have an enormous effect on what our country and our society looks like. But I'm going to talk about the cases, and it gets a little complicated, so fasten your seatbelts. I've talked about this before in different ways, so I hope I can make it understandable to those who are fortunate enough not to make their living as lawyers. As was said, Robert Jackson is a presiding genius of this town and of this institution. He was an eloquent, brilliant, flawed man, dedicated to untangling all sorts of knots, figuring things out. The famous opinions that one knows about are the Wickard case, the wheat farmer who was told he could not grow wheat to feed his family and his pigs as a difference, and who thought that was unconstitutional, and the Supreme Court set him straight. The Barrett case, which you all know, which contains maybe Jackson's most famous and eloquent statement, repeated by Chief Justice Roberts just this term in a case having to do with pledging allegiance to the administration's anti-prostitution policy, which is a slightly different context than the flag salute. Here is what Jackson said. It's really worth reminding ourselves of it. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by words or act their faith therein. Now here comes a typically Jacksonian sentence. If there is any circumstances which permit an exception, they do not now occur to us. That wonderful, colloquial, demi-semi, humble statement is typical Jackson and typical of a man who did not want law to become submerged in incomprehensible technicalities. Well, there is, after all, a a kind of apostolic succession at work here. From Jackson, we have his law clerk, Jackson's law clerk, during the school segregation cases, one William Rehnquist, who became Chief Justice and who has lectured here. And his law clerk was one John Roberts, who became Chief Justice and lectured here, and who will figure prominently in my remarks. Now, let me start with the healthcare case. There were enormous political stakes in that case. This was to be President Obama's signal accomplishment of his first term. It was also the most extensive extension of the welfare state for many decades, maybe even since Medicare in the mid-60s. So it was remarkable in that sense. It was also remarkable because not a single Republican senator or congressman ended up voting for it. Further, it was remarkable because by a series of complicated maneuvers, the statute which had been voted out of the House of Representatives before the new Congress, the new Republican Congress, took its seat, did not have to go back to that Congress. Instead, it went to the Senate, and by further complicated maneuvers, a filibuster was not permitted, and the program was enacted. Well, the procedural history is a large part of the bitterness that this statute evoked in its enemies. But there was also an important principle and political enmity, and that was the mirror image of its virtues. And that is, of course, this was a case about an extension of federal power over the ordinary citizen, and in that sense, it was viewed as a case about liberty. And if you will recall from the various meetings of ordinary citizens wearing funny three-cornered hats, it was a signal instance of the overreach of the federal government instanced by the Tea Party. So this was really a big deal politically. Furthermore, if the Supreme Court were to throw this out, it would not only destroy this signal achievement of the Obama administration, it would save the Republican Party in a presidential election from having attacked Obamacare to come up with an alternative. It wasn't their fault. They didn't vote it out. They didn't repeal it. The Supreme Court did. So there were big political stakes. But there was also a very big problem. The problem was, while this was a case about liberty, what provision of the Constitution did it violate? The natural home for that attack would be the Fifth Amendment, which says that no person shall be deprived of liberty without due process of law, and so this was a deprivation of liberty. That would be the textual hook for an attack. Unfortunately, that hook was unavailable. It was unavailable because there is an identical clause in the 14th Amendment which applies not to Congress but to the states, and it has been regularly interpreted to have the same meaning, which would result in the fact that if Obamacare had been struck down as unconstitutional, so would Romneycare, which was a state statute, and so would any attempt by any state to have a similar program enacted within that state. So, as I say, that hook was unavailable. Where to turn? The Commerce Clause. The administration said, well, or actually Congress had said, that it was invoking its power to regulate commerce. It rather specifically declined to say that it was invoking its power to impose a tax. Why? Because Congress did not wish to be seen as increasing or imposing new taxes. So, Commerce Clause seemed to be it. And the Commerce Clause attack is not one which says that Congress has done something which violates a constitutional prohibition. It says rather that Congress has outrun its constitutional authority. Congress has no authority to do this. And when that attack was made, it seemed to everyone extraordinarily weak. Extraordinarily weak because, unlike a few two recent examples which the court did strike down, this enactment clearly had to do with the economy. The Violence Against Women Act clearly did not have anything to do with the economy. Beating up your girlfriend is not an economic act. Neither did the Gun-Free School Zone Act, which the court had struck down, because carrying a gun at a school is not an economic act. But the business of medicine is 18% of the national economy. So, what in the world can one say about this? A very clever man, a professor at Georgetown, a former student of mine, Randy Barnett, came up with what I shall be referring to as the broccoli argument. That argument says, all very well, Congress can do practically anything, so long as it doesn't violate the First Amendment or something of that sort, to regulate the economy. But the economy has to do with being in some kind of business or relation. What the Obamacare mandate did, the mandate that you must buy insurance if you don't have it, does, is it tells people who are not engaged in a business, who are not engaged in an economic relationship, that they must first of all get into one, and then we will regulate them. That's the idea. And that was the picture. It's a very bad argument. It's a very bad argument for a number of reasons. First of all, because in any 5-year period, 95% of the adult population is involved, uses the healthcare system. And I don't mean by buying an aspirin. I mean by visiting a clinic, going to a hospital, getting a prescription, getting a prescription drug. And in any 1 year, 85% of the population. And I would have thought that's good enough for government work. So the idea that people were being forced to enter an economic relation so they could later be regulated seemed a non-starter. Now, I'm a registered Republican, although people scoff at that. Many people I know on all sides of the ideological ground and also in academia thought this was a nothing case. It was 8-1, only Clarence Thomas voting against, and voting against for the reason that for decades he has expressed a different and a perfectly respectable, but simply outmoded notion of the Commerce Clause, shared by no one else. So it seemed like no one else on the board. So it seemed like a slam dunk, 8-1. The fact that, by the way, that it seemed like that to academics is one thing. Another thing to notice is if you look at the betting, the betting websites, the people were actually putting money on it at that level, and that really to be taken seriously. But the broccoli argument, nonetheless, kept going, and in fact, 2 district court judges of no particular distinction brought it. I remember testifying before the Senate Judiciary Committee on this subject, and Senator Sessions said, "Mr. Freed," and this was the standard broccoli argument being thrown at me. "Do you mean to say that because broccoli is an item of commerce, the government, in its desire to improve our health, can make us all eat 2 portions of broccoli a week?" And I said, "Certainly not, Senator Sessions. That would be a violation of your liberty. But what it can do, and what it regularly does in other contexts, is make you pay for it. And then, whether you pick it up at the grocery store or not, and if you've picked it up, whether you eat it or not, that's your business." And similarly with health insurance. You've got to buy it. Whether you use it or not will then be up to you. And so it seemed okay. And 2 very distinguished and very conservative, much more conservative than me, judges, Judge Silverman on the D.C. Circuit and Jeff Sessions on the 6th, made exactly the same argument. So it seemed, again, 8-1. But politics were heating up. The campaign was in full swing. The Republican nominee by that time, which was March of 2012, was certain to be Governor Romney. And then came the argument at the end of March. And the one person that it was thought of the usual, if you know, round up the usual suspects, the usual suspects being Roberts, Scalia, Kennedy, Alito, Thomas. You round up the usual suspects. Kennedy seemed to everybody to be the one most likely to break ranks. And having broken ranks, that would give 5 votes to the other usual suspects. Ginsburg, Breyer, Kagan, and Sotomayor. And there you would be. And once there was an assured majority there, Roberts, probably unwilling to let the matter go to them, would join forces and would write the opinion, and then probably Alito, or maybe not Scalia, which I have seen fine. However, right out of the box, in the first 2 minutes, Kennedy comes steaming out with the question to Don Verrilli, the Solicitor General. Mr. Verrilli, let's put all the technicalities aside. Don't you think that if the government could do this, it would be a fundamental change in the relationship between the citizen and his government? Don was so astonished by this that he had to take a drink of water. It went down the wrong way. He had a coughing fit, and by the time he recovered, they moved on to something else. I would have said, Justice Kennedy, you're absolutely right, except for one thing. That fundamental change occurred 75 years ago with Social Security and 45 years ago with Medicare. However, they had, as I said, moved on to other things. So, that was Kennedy. And then the other of the usual suspect, including Roberts, did what I can only refer to as piling on to the Solicitor General with broccoli-type arguments. At the end, in the last few moments, Verrilli did get a chance to say, and Your Honors, we do want to remind you that in our brief, the government also thinks that it was entitled to do this under the taxing power. Well, here is the first mystery. The case was decided at the end of June. Chief Justice announcing the opinion. Chief Justice, so we guessed right. Kennedy had joined ship. Roberts had joined him, so on and so forth. Here is what the Chief Justice said. Having described the statute, he said, "That is not the country the framers of our Constitution envisioned. The government's theory would erode those limits, permitting Congress to reach beyond the natural extent of its authority. Congress already enjoys vast power to regulate much of what we do. Accepting the government's theory would give Congress the same license to regulate what we do not do, fundamentally changing the relation between the citizen and the federal government." My goodness, it's the broccoli argument. And CNN can be forgiven for having rushed to the teletype machines and the television cameras to announce that the Supreme Court had struck down Obamacare, violating a primary rule of the legal profession, which is read on. Because, having said this, the Chief Justice then said, however, under the taxing power, this is all right. Well, that was astonishing. The taxing power was an afterthought. And as I say, Congress really was not very interested in pressing it for reasons I gave. And the government did mention it, and I'm sure they were very glad they did. Well, that was a real mystery. First mystery was that the government, that Roberts signed on to broccoli. The second was that having signed on to broccoli, he signed off on the tax thing. Then, having done that, having said the statute is constitutional under the taxing power, comes another mystery. If, in fact, the mandate is constitutional, why spend pages and pages, not to mention the flag-waving possibilities, of talking about the broccoli argument? There were many other bad arguments, if this was a bad argument, that might not have sustained it. But, one good argument is enough. And if it's constitutional, you announce that and go home. But he didn't. He didn't. Why not? Here is his reason. Because the Commerce Clause does not support the individual mandate, it is necessary to turn to the government's second argument that the mandate may be upheld as within Congress's enumerated power to lay and collect taxes. It is necessary to turn to it. Chief, you got it the wrong way around, remember? If it's constitutional, it is unnecessary to talk about all the other powers which don't sustain it. The treaty power, the bankruptcy power, the power to coin money, post offices. Yeah, all right. So why did he do that? And he's a very fine lawyer, very fine. The justices almost all said that in the 11 years or so that he was an advocate before them. He was the best they heard. So that's a real mystery. Why did he do that? Comes the next mystery. A dissent. A dissent which joins Scalia, Kennedy, Thomas, and Alito. Oh, who's writing? You know who's writing? They're all writing. It's as if they had four hands on the pen. It is called a joint opinion. Very unusual. Very unusual. In my experience and in my knowledge, I know only 3 joint opinions. The usual thing is one person gets credit for writing the opinion and the others join. That's it. That's the usual thing to do. This was a joint opinion of all 4 of them. The other cases were Cooper and Aaron, which was the Arkansas desegregation cases. Justices O'Connor, Kennedy, and Souter in the Casey case, which reaffirmed Roe v. Wade, and Justices O'Connor and Stevens in a case saying that campaign finance regulation was constitutional. Very, very rare. 3 in a very long period of time. So they were trying to make a statement. What was the statement? Well, why were they making a statement which was identical with that their colleague and brother-in-arms usually had made at the beginning, irrelevantly as it turned out, of his opinion? Moreover, why did they not just say, we agree with that? Instead of any of that, what they did was not mention. There is no mention of the fact that the very same argument they were making had just been made and endorsed with enthusiasm by the Chief Justice. It's as if it didn't exist. In all my reading, I have never seen such a concerted dissing of a Chief Justice by his colleagues as that gesture represented. Extraordinary. Extraordinary. And I want you to sort of pause to think about it. Well, why did that happen? For instance, why did the chief give the irrelevant part of his opinion? And why did his colleagues turn on him in what is, in the polite world of the Supreme Court, a rather vicious way? Well, there are all kinds of theories. One of them is that the chief, who is a consummately intelligent and knowledgeable man, was engaging in what is referred to as the long game. Plant you now, dig you later. A great expert at plant you now, dig you later was Justice Brennan. If I had the time, I'd give you some of the examples. So that's one idea. So he was willing to weather the scorn of his brothers in arms in order to make this gesture for the future. Another theory is that he was simply trying to retain some of the good feelings of his natural political allies. I don't think any of that is the case. I think the case is really quite different. That first part, what became the irrelevant part of the opinion, was the opinion of the court. That was Roberts' opinion. It was not some kind of a gesture. It's what he felt. And you could tell from his behavior in the argument that that is what he felt. But then he thought again. And he worried. And his professionalism overtook his partisanship. And he realized that, in fact, his job is to declare the statute constitutional if it can be done. And he saw that it could. And if it could, it must. And that's what he did. That's what he did. So this was not a case of some supremely devious trick. It was a case of what I would refer to as the fog of war. A contentious situation with high feelings and very little time, and that's how it came out. In his confirmation hearings, Rehnquist said that I have no agenda. My job is that of the umpire. I just call balls and strikes. Well, he called a ball a strike a ball, and the batter got on base, so no harm was done. Now let me turn, and it'll have to be briefly because I welcome your questions, to the same-sex marriage cases. There were two of them. One of them is the Doma case, in which Congress had decreed that no matter what a state says, and by now 13 states have said that we will allow same-sex marriage, no matter what a state says, the federal government will not recognize it, and for the some 1,000 federal statutes which speak of marriage with spouses and so on, that term is limited to one man and one woman. And that has enormous practical effects for joint tax returns, for Social Security, for estate taxes, and so on. And that had been struck down by a district court and two district courts and two federal courts. And it was now in the Supreme Court. And the Prop 8 case was a situation where the Supreme Court of California has said it violates the federal Equal Protection Clause to deny same-sex couples the right to marry, and it denies, it violates the state the state equal protection laws and then